I wish I had a set of statutes here. If I possess my neighbor's electric bill, am I unlawfully possessing personal identification?
I have filed cases like that in the past, filed informations on them. I've considered it such. My office usually does.
Judge, if you already know your neighbor's name and address, and I think you have to have illicit intent, Judge.
Well, I understand. All that I'm asking is whether the statute covers that. I know that personal identification is a, Florida ID card or a driver's license or, a passport or, some other form of official identification. That's why I asked, because I don't have the copy of the statute before me.
I get the wording.
Billing statements usually have financial information or things like your social security number on them.
Judge, personal identification information as defined in 817-5685 means a person's social security number, official state issued or U.S. issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer identification number, Medicaid or food assistance account number, bank account number, credit or debit card number, and medical records. So just having somebody's mail does not fit under the personal identification information unless they're stating that that information was within the mail. And that's not what they're stating.
I would imagine that checks would.
The checks and the billing information would both have things like the financial information mentioned, like the banking account numbers.
Just with regard to probable cause for Miss Bernal, it just indicates that she's a passenger in a car and that there's some mail scattered in the car. There's nothing indicating she was aware of the information inside whatever paperwork in the car she got into. I know when I hop into somebody's car as a passenger, I don't rummage through the car and open up paperwork to see what's in there. I don't check under the seat. I don't go look in the glove compartment. I get in the car and I get a ride and I go somewhere, but I don't search throughout the car when I get in, Judge. So there's nothing indicating any knowledge by Miss Bernal of the contents of the vehicle.
Where is Javier Torres? What page is he in?
He's number 52.
Didn't we already call him? I think we called him out of turn earlier.
Did we call Javier Torres out of turn?
Yes, we did.
Madam Clerk, do you have that A report?
It's on page 20.
I apologize. Oh, if you can just pull it up on your computer, I can read it from here.
The A form appears to be identical, just changing the co-defendants to defendant when it talks about Mr. Torres.
Yes, that's right.
I was just looking at the address. That's why I asked for it. Where do you live, Miss Bernal?
In Sunny Hills.
Who do you live with?
It's my grandmother's apartment.
Where do you work?
So I'm a real estate agent, and I also work in pharmaceutical sales.
My place on pretrial services. I'm going to RR you on this charge.
So Judge, so it's just
Well,
RR?
well, you all don't accept any person with RR?
Yes, Judge, we can do an RR, but
No,
pretrial,
well, a pretrial will not accept that. I want her to be on pretrial services, so can I put $100 bond and you will accept her? $100 bond,
okay,
alternative bond with pretrial services.
thank you.
Because I assume, the reason I was gonna ROR is because I assume that she will be under pretrial services supervision. If that is not the case, then she will be remanded into custody. Okay, good luck to you. Jonice Lanier. State, what's your recommended bond? I sign an order prohibiting any contact, not that it means anything, because you're here for violating an injunction.
We would ask for 2,500 for count one and 1,000 for count two.
2,500, 1,000. Terrence Bennett,
So Judge, are you giving Ms. Lanier a stay away order?
I think I had one. I signed it.
I thought you
Judge,
announced it on
if
the
you
record.
just sign them and you don't say it out loud. and
I
give-
did. I said, I'm signing an order requiring you not to have any contact with the victim. I thought I said that. And I said, it may not matter at all because she's here for violation of injunction.
Okay, you didn't, okay, you didn't mention any names or initials or,
Cynthia Watson,
okay. You understand?
Terrence Bennett, Mr. Bennett, you're before the court charged with aggravated assault and domestic battery against your sister. Who owns this house?
Mama own the house.
His mom.
She kicked me out of the house. She don't must don't like me. You know?
Is your mother, does your mother, obviously, she probably knows that you're here, right?
Does your mom know you're here in jail?
Yeah, no.
No?
Yeah, she don't have. My dad do.
Is anybody on Zoom, on behalf of Mr. Bennett?
If you're here for Mr. Bennett, please raise your hand or type in the chat, please.
Do you work, Mr. Bennett?
No, no, Your Honor.
Did you say yes or no, Miss?
No, Judge, he receives Social Security disability income.
Let's see. How about your sister? How old is she?
She's 21.
Does she work?
Yes.
What's your recommendation, Miss Corey?
One moment, Judge. Judge, I would ask if you would consider a reduced bond and perhaps he will be able to live with his father. Pending this case, his father lives a distance away. He's not sure if he can live with his father yet, but he'll
Oh
have to reach out.
my auntie, but she lives in Center Citizen.
She's where?
My auntie live a senior citizen.
Senior citizens?
Yeah, senior citizen.
His aunt is a senior citizen.
My mother-in-law, her boyfriend got in the program with house.
I'm entering a no violence, contact order. There'll probably 1,500. Good luck to you. Anthony Copa Vaughn.
Judge, can Mr. Bennett go back one time with the police to get his belongings?
I enter a no violent contact order.
I can't
Okay.
get contact.
Mr. Copa Vaughn. What's your last name, sir?
Well, Kavanaugh, sir.
Yes,
Hyphenated.
yes, it's Kopaka Vaughn. You're charged with possession of cocaine, possession of methamphetamine, possession of less than 20 grams of cannabis. How long have you been homeless? If you are,
Well, I'm not really homeless. I have a friend's couch that I sleep on every once in a while. The address is I can give it to you if you like.
Ms. Corey,
Judge, I would ask for the TAP program for Mr. Gilvagaban, and then they can confirm the address.
place your TAP program, counts 1 and 2, $1,000, alternative bond, $1, possession of less than 20 grams.
And Judge, can we give him a future court date?
September 5th. Chad Thomas.
Your Honor, on the female that we passed before, Chante Wallace, we need to reset her for tomorrow. She refused court.
It would. I'll set it for tomorrow, Miss Corey. This lady, well, she's not granted. I'll set it for tomorrow. Chad Thomas. Mr. Thomas, you're charged possession of cocaine. I find probable cause.
Would you consider the TAP program, Judge, for Mr. Thomas?
Your bond will be $1,500 alternative to TAP September 5th. Excuse me? Yes. What did you doubt? Were you doubting me? Did you doubt my decision-making ability? You know what I call this, days, man? You are all on an Arias diet today. We're gonna be here till like 2:00 to continue at this rate. Page 9, Jack Voltaire. Yeah. Yeah. I know. I guess the correctional office notice to appear machine broke last night. For today, for God's sakes. No, I'm not be here tomorrow. Jack Voltaire, Mr. Voltaire, you're before the court sir, charged with aggravated battery on a law enforcement. Wait a minute. Yeah, aggravated battery on a law enforcement officer. Resisting with violence, How long have you been in South Florida?
Since 2004, Your Honor.
States what your recommendation?
Repeat that again, Your Honor.
No, I asked the state attorney what his recommendation with regards to bond is.
We would ask for 5,000 for the on the Bat Leo. Just a punch in the face. This would be filed as just regular Bat Leo, and then 1,500 for the for another 5,000 for the resisting officer with violence.
Your bonds will be 5,000 on each count. Yes, Manny Alvarez.
Your Honor, he's a violent felony offender of special concern. He's on probation on F252840.
Judge, I'm sorry, Mr. Voltaire indicates he does not have funds for a $10,000 bond. However, he thinks he could afford a $5,000 bond. Would you consider a $2,500 each count, Judge?
I would consider it, but deny it, ma'am. Thank you.
Would you consider any reduction, Judge?
I would consider it, but not reduce it.
So what's the bond?
Ms. Corey, will be an abuse of discretion for the court not to consider the motion. So when you ask me, would I consider? I would always consider it, but it's denied. Even though the state said that the defendant punched the officer once, that is correct, but he punched him several times. Yes, Manny Alvarez, sir, you're before the court, you're on probation.
Your Honor.
And at this time, you're here on a grand theft.
Yes, Your Honor.
State, how often do officers neglect to put down the monetary amounts?
Yeah, it is quite often.
Well, but, doesn't your office volunteer to give seminars?
I mean, I would hope so. I would hope we would teach them to do it correctly, but yeah.
If I find probable cause for petty theft, your bond will be $1,500
With the hold, Your Honor?
with a hold for a violation of probation. With the no contact order to Verizon. To be honest with you, this is my last day, and I should not be so critical, but I have never sat in any courtroom where probable cause has been such a often issue.
It's constant, Judge, that
I'm telling you, but I mean, there's no reason, rhyme or reason for being constant.
I agree.
And I mean, I don't have anything against Metro-Dade or any of the office police departments here, but it's just elementary.
They're expecting them to finish elementary. Delivering excellence.
1,500.
1,500, yeah.
Lázaro Valladares,
NBC, Your Honor. Contact isolation. Reset for tomorrow.
we set it for tomorrow. Levy Land. Have you all noticed I'm not calling out judges' names anymore?
That was only the first day, Judge.
Yeah.
All right, let's talk about that. This docket had a little bit of everything: confusion over statutes, a debate on what exactly counts as personal ID, some surprising employment combinations, and, of course, the usual colorful courtroom personalities. Judge Chris Martin kept the train on the tracks with his signature mix of sharp wit and judicial patience. There were moments where the legal discussion turned into a bit of a philosophy, seminar-like the lengthy back and forth over whether an electric bill counts as personal identification. One attorney was ready with the statute, while the judge openly admitted he didn't have the book in front of him, which led to a surprisingly productive conversation. We even got a breakdown of what personal identification legally includes. Your neighbor's water bill isn't on the list. Miss Bernal's case was a standout. She was just a passenger in a car with scattered mail, and the judge made a fair call, noting the lack of probable cause. His logic: most folks don't hop in a friend's car and start rooting through their glove box. Fair point. Miss Bernal came across as composed, and we even learned she juggles pharmaceutical sales and real estate. Someone's staying busy. The judge was set to release her on her own recognizance, but made it clear that release hinged on supervision by pre-trial services. When that didn't align, he pivoted with a $100 bond plus pre-trial, showing flexibility while keeping accountability in place. The hearing later turned into a bit of a family counseling session when Mr. Bennett appeared before the court for an alleged altercation with his sister. His responses were scattered, at times hard to follow, but the judge remained composed, entering a no-contact order and discussing possible living arrangements. You could tell Judge Martin was doing his best to balance public safety and fairness, even fielding a request to let Mr. Bennett return home briefly with police to get his belongings. Then there was the moment of comedy gold from Mr. Scopacaven, who clarified that his last name is indeed hyphenated. While standing before the judge on a mix of possession charges, he admitted to couchsurfing, but had an address handy, and the judge gave him a chance with the TAP program and a $1 bond on one of the charges. The energy shifted when Mr. Voltaire's case came up. Charged with battery on an officer and resisting, he hoped for a bond reduction, arguing he could swing $5,000 but not $10,000. The judge delivered a masterclass in polite consider it but deny it, which prompted one of the few courtroom laughs of the day. Throughout, Judge Martin balanced legal precision with a healthy dose of humor, even taking a jab at inconsistent probable cause write-ups and wondering aloud about the effectiveness of officer training seminars. It was a marathon morning of cases, but the judge held the room with steady control, clear reasoning, and just enough personality to keep things from dragging. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts. In the comments below, I read every one.